Under new business, we have the sexually oriented business ordinance. I'd like to invite Attorney Paul Smith to come sit up here and educate us on his ordinance.
Sit here, all right, Mr. Chairman. I don't know if you're recording or how you work. Good evening. For the record, my name is Attorney Paul Smith. My business address is 27 South Main Street, Windsor, Connecticut. I represent a group called Windsor Citizens for a Safe Community, so kind of an acronym that maybe has something to do with the police commission, because that's what you're all about, a safe community. And I appreciate, Mr. Chairman, the opportunity to come and speak to you tonight on behalf of the organization that I represent. It's basically, let me just explain, an ad hoc group of people from the town, citizens, both individual and corporate landowners. Most of those landowners up on Route 75. And we meet periodically informed out of the concern that we learned that there was an application at 75 Allegrass Turnpike for a proposed strip club at the site, which is now known as Pool Table Magic. And our purpose really is, with regard to Pool Table Magic, we don't think it's an appropriate place for a strip club. But we took really sort of a multiple task way of trying to approach this issue. Strip clubs, sexually oriented businesses are kind of a unique land use. And what I mean by that is there are a series of court cases, federal court cases, starting with the U.S. Supreme Court back in the 1960s, that categorize these type of activities as having some First Amendment protections under the U.S. Constitution. So, unlike a normal commercial business, a restaurant or a hamburger stand, the town can simply zone it out of existence. Say we don't allow hamburger stands in town, so there are no hamburger stands. We don't want gas stations. We don't have to have gas stations. The court cases starting back in the 60s say you can't exercise that sort of control over a strip club or businesses that are sort of fall within that penumbra. And so what you have to do is, to a certain degree, you must, the general proposition is you must allow them at some location within your community, but you can regulate them. And the ability to regulate really arises out of the fact that there have been a number of studies over the last 30 years which strongly indicate that when you have a sexually oriented business operating within your community, that there are bad secondary effects from that, pernicious, what we call pernicious secondary effects, such as increased crime, prostitution, drug use, assaults, and that also you have, because of that, a problem with property values. Property values around these kind of these establishments tend to diminish. And it's for that reason, the second reason, that we have some of the corporate people that own properties up on 75 run hotels, gas stations, are concerned that if something like a strip club goes in that Pool Table Magic, how's it going to affect their businesses which are located next door? So in terms of our multi-dimensional approach to the problem, one of the things we've done is propose to the Board of Selectmen a sexually oriented business ordinance, which is attempts to regulate the business if it were to exist from a health and safety standpoint. And because it regulates it from a health and safety standpoint, unlike a zoning ordinance, there is no sort of grandfathering. If the business goes into effect, whether today or in the future, it would have to comply with this ordinance if the ordinance is passed by the town. And just for everybody's edification, generally ordinances are allowed, first of all, they're reviewed by the Board of Selectmen, and they vote on them, and then it's sent to a town meeting, and it's then adopted or rejected at the town meeting. So it's a public sort of procedure, ultimately with a town meeting vote. And so we've all the material. I have a copy of this which I can leave with you, Mr. Chairman, and I already emailed you the ordinance, which I think you probably circulated.
Yes.
Did not think it was necessary to give, but you know, if you want additional copies, happy to make them available. Copies of what are the underlying studies in the case law which sort of promulgated the ordinance. One of the requirements under the case law, and again, this started in the 60s, so as a matter of law, sort of cases develop over time, the theories develop, what you can do, what you can't, you know, what's allowed, what isn't, in terms of protecting First Amendment rights and, you know, the conflict of trying to control this kind of activity. So basically what we did in terms of the sexually oriented business ordinance, which we have before you tonight, is we looked at a number of towns in Connecticut and actually in other states and what they had passed in terms of ordinances. And the body of work that's in this sexually oriented business ordinance that we've proposed really has its genesis in the town of East Hartford. They, about 4 or 5 years ago, spent about a year working on an ordinance. And the ordinance that you have in front of you is pretty much the boilerplate of what they had, sort of changed to a certain degree to match, you know, our town governing structure. East Hartford, unlike us, has a town council, and that basically serves a multitude of purposes. They don't have town meetings, everything is through their council and that sort of thing. So we tried to sort of modify that to fit our governing structure, and we then also looked at additional case law and additional studies that had been done even since they were considering the ordinance, again to try to bolster the case for the appropriateness of this kind of health and safety ordinance. And one of the requirements under the case law is you just can't adopt the ordinance. You have to have some background material reviewed that supports what you want to do, and that's the reason for the multiple binders that I'll give you. In terms of the ordinance itself, it really does a couple of things. First of all, it creates a rather extensive licensing process, both for operators and people who actually are entertainers at these type of establishments. It also puts on operators and people who are involved in this kind of activity certain requirements. They can't have basically, you know, serious criminal records. Anybody that's going to work as a entertainer at these kind of establishments has to be licensed yearly. So we're talking about sort of background checks, that sort of thing. And what we've done, and I think where it impacts your board and the department, is obviously the first selectman. We've made the first selectman, but again, it's up ultimately to the town to sort of, with a dialogue with us, to figure out who do we want really sort of in charge of this. We as a default position put the first selectman. Because this is it's not solely a police function. It's, if you will, it's a little bit broader than that. But it would require some intervention even in the application process with the department. I assume they would have to do a background check. I mean, obviously the first selectman's office doesn't have that kind of capability. And then there are things such as timing issues. I don't know how long a background check would take or wouldn't take. We put time limits in here, and one of the things you do find with court decisions in this area is you can't set up an application process and make it so long for someone to get an approval that you're infringing on their ability to do this. In other words, extreme example would be if someone comes to the town and says, I want a license, I'm gonna work at this establishment, and you receive the application, but you don't act on it for, say, 6 months, okay? The courts would consider that a violation of the First Amendment, because this person, you know, can't do it. You've got to have some sort of streamlined activity. So that's one of the things I wanted to sensitize the commission to. Again, with regard to the second part, is not only an application process for the operators and owners and the entertainers, there is a significant section which speaks to controlling the actual activity on site. And some of the main highlights of that is, for example, for a strip club, we would not allow totally nude entertainment. You would have to have, you know, some coverage, bikini, that sort of thing would be sort of what's in mind. Number two, there would be a requirement on the interior of the establishment that there be continual surveillance as long as they're open of the establishment. Third thing would be there's no contact between the entertainers and the patrons. That they perform on a stage, that the stage be a distance from the patrons, and that any tipping or any of that sort of thing be done through an affixed tip jar versus, you know, some other form of tipping. And the idea again there is, and if you look at the studies and the case law, there's a strong suggestion by doing that you tend to sort of limit the things such as someone, you know, sexually assaulting someone because, you know, they're performing. You tend to limit the, you know, the opportunities for solicitation of prostitution and that sort of thing. So there's a whole host of reasons that those kind of controls are put into place. And so that's really sort of the main emphasis, and it does also obviously have a section that indicates that, you know, if there's violations, the first selectman can, you know, basically convene a hearing and revoke the license of an establishment or take other kind of punitive steps. So it has a whole host of, it's a fairly complex ordinance. It has a whole host of those sort of issues. We've also put a rather extensive section in on massage parlors. Again, really just copying, frankly, what East Hartford had. It isn't an immediate concern, but when you're addressing this, you might as well try to address it, you know, as completely, as holistically as possible.
Sure.
I'm certainly open to any suggestions or comments. You know, one of the tricky parts of these type of ordinances is if there is an establishment that wants to go in, and we are in that circumstance. There is someone very, very much interested in putting this type of business in town. They are actively engaged with council in terms of updating you on where that all stands. They had submitted an application to the Planning and Zoning Commission, which is our board which regulates land use. They submitted what's known as a site plan for approval, or site plan approval, which is functionally, for that board, the sort of the simplest and lowest level type of approval. The board voted I want to say last week, I think it was, time flies, but they voted recently, let me put it that way to be safe, but I think it was, yeah, it was last week. They voted to reject the application under the position that this type of use proposed by the applicant required what's known as a special use permit. That's a little bit different than a site plan. Has more extensive criteria, and it gives the planning board more flexibility in accepting or denying. There was a regularly scheduled meeting of the Planning and Zoning Commission on February 11th, this Monday, and the applicant did not resubmit a new application, and they could have done that. My sense is and again, I don't know this as a fact, and it's somewhat speculative because I've never talked to their counsel, but my guess is they may be at this point looking at engaging the town in some sort of lawsuit saying, you know, we want this, and they denied us, you know, the right to have it. So that's sort of where it stands in terms of, you know, that material application. There are, the board should be aware, several existing ordinances that regulate what they describe as adult businesses, or more explicitly under this ordinance, it's sexually oriented businesses. Those are distance ordinances generally. Those require that no sexually oriented business be within 1,000 feet of each other and 500 feet of a residential zone.
So this ordinance that you're proposing with the current ordinances, what kind of
There is some overlapping, but we don't, this ordinance doesn't get into distances.
Okay.
We sort of left that alone. My sense is we're probably about at the maximum distance issue.
Okay.
I mean, if I could in good conscience encourage the town to increase the distance, and I thought it would successfully withstand the court challenge, it's something I would look at. But 1,000 feet, you know, you see that a lot in the court cases, it's sort of, and that looks to be a, you know, unless you have a much larger town, for example, where, you know, it was 2,000 feet, it wouldn't make a difference. But in our town, 1,000 feet is actually pretty significant in terms of activity, given how small and compact the, you know, community we live in.
Sure.
The other thing I would say is that these type of ordinances, when you have someone that has an interest in a business, you know, is likely, in all likelihood, to be challenged. I mean, we'll adopt something, the town will adopt something, and if the business is successful going through its zoning issue, then they probably will challenge this ordinance. Now a similar East Hartford ordinance was challenged, and the outcome, it was not fully litigated, but the outcome basically was that the clubs in East Hartford sort of acceded to the fact that the ordinance was valid.
Okay.
So it was basically left intact from that challenge. Does that mean it's a perfect ordinance? It's hard to know, because you know, it's a really complicated area of the law, and some of these issues probably haven't been fully vetted, you know. Can you require surveillance on the interior? Well, there's good reason to require it, and there are some cases that say you can, but again, you know, whether someone's willing to take it all the way, you know what I mean, to its full conclusion, it's hard to know. But I think it's a good start for the town. I think it's important. You know, my group recognizes that the law says that these kind of activities have constitutional protections. We don't maybe philosophically agree with that, but we recognize what the law is. And so the purpose of this ordinance is not to prevent. The purpose is to regulate, and through regulation mitigate the effects, the bad effects that these kind of activities have. We have no, you know, talking to people in the business community, talking to individuals, I mean, there's no doubt in our mind that there are bad effects to these kind of activities. One of the interesting things is, because of the internet, as we all know, you can access and research all kinds of materials that maybe 20 years ago weren't available to us. But as we were putting this together, one of the things we sent out to everyone, we didn't send it to your group, Mr. Chairman, but there was actually an article about the fact that some of these kind of strip clubs are basically used as basically the feeding ground for prostitution rings, where what you do is you get some, you know, younger person, more innocent, not sort of as worldly, introduce them to this as sort of the gateway, right? You can come and you can dance, you know, and from there you tend to isolate them from their family, their friends, their community, and then sort of move them from this into full-fledged prostitution, where they're sort of pretty much isolated, you know. and therefore more vulnerable. And, you know, as we all know from the recent issues in town, that, you know, these things exist. They exist in Windsor Locks as well as everybody else, everywhere else, unfortunately. So I certainly open to any questions or comments. I have had actually some good input already from you, Mr. Chairman, and from other members of the board, just by way of notes. The issue of whether we should try outside as well as inside surveillance, I think you raised that with me, and I appreciate that, and it's something I would really look at closely putting in the ordinance, and I favor it. My default position is let's put it in, and then, you know, if it's contested, if that part fails, so be it, you know what I mean? Or if the inside surveillance issue fails, so be it, but, you know, there's no harm in putting it in, and it seems like, it doesn't seem like an overt, inappropriate way to try to regulate. The other thing that I did get from one of you was the issue of, to make sure that their surveillance equipment that they use is something where you can take the disc and play it on a system at the police department or here or somewhere, that it's not proprietary, so that it only can be played on, you know, their machine at their location. Because again, that I think would create a burden on the police department. If you wanted to look at a tape or a CD, I guess is what it is now, that you'd be able to take the CD and look at it versus, you know, having to look at it at their establishment. I mean, I just think in terms of time, and, you know, and level of comfort, because you may be looking for something that you don't want them to know exactly what you're looking for. So that made some good sense to me. I'd have to sort of get some sort of language that meets that criteria, but I think that's reasonable. But again, open to any other suggestions that the members of your commission have. I know this is a rather lengthy ordinance. This is not sort of, you know, give me your comments tonight, or you know, you're forever barred. Anybody can submit their comments to the first, you know, to the first selectman, to the board of selectmen, to me. We're pretty much open to looking at anything. We did at one time when we were discussing this, we thought about, and you and I had talked about this, Mr. Chairman, the idea of, you know, should we require, like with the Teletheater, you know, a police presence on site. I haven't seen that as an appropriate sort of requirement in any of the ordinances. And the other thing that you brought out, which is correct, this would not be a non-hostile environment for an officer, would be my guess. So it would be sort of, you know, a pretty difficult place for him to be alone. You know what I'm saying? You know, again, it's one of those places where you can very easily be accused of sexual assault, you know, inappropriate touching, you know, it can run the gamut. So at first blush, that does not seem to be a good alternative, and nothing that I've seen. I'm not sure the court would particularly care for that, you know, because it's such a heavy, you know, heavy burden on the establishment and on the patronage, right? You basically have a police presence there while it's in operation. So I don't favor that, but again, I'm open to, you know, somebody could find me a case that says, yeah, it's a great idea.
I don't think the police officers' wives would be in favor of it.
I'm sure they wouldn't be. But again, you know, and again, it's about burdens too, right? Now, obviously, if we did it as a teletheater, the operator would be required to, you know, reimburse the town. But again, in terms of manpower and usage, I'm just not sure in that kind of environment that would be an easy assignment.
Electronic surveillance, is that standing up in court? Is something that?
Yeah, again, the East Hartford ordinance had it. It was challenged, and it, like I said, it wasn't completely adjudicated, but the final resolution they reached, it stood up. So I'm certainly willing to keep it in there and push it forward.
Chief, maybe we could reach out to East Hartford PD and just see how that.
That's similar to the pawn shop.
Yeah,
Requirement.
right. You know, and again, it's not about trying to sort of prevent the activity. It's trying to dampen down, you know, the kind of sort of illegal stuff that you don't want going on. And excuse me, if we pass an ordinance like this, which has, you know, fairly strict compliance in it, pretty hard to know that compliance is ongoing without some sort of surveillance, you know? That, you know, for example, that there is not total nudity, that, you know what I'm saying? That there is not, you know, inappropriate contact between patrons and entertainers, you know, that sort of thing. So you need something in place that allows the town to do that in a sort of seamless way.
You said there's tapes gonna be made?
Well, you know, tapes,
Okay,
that's sort of,
let me
an
continue.
older anachronism.
Yeah, I understand, whatever they
yeah,
are,
there's-
CDs.
There will be recordings of the video.
Okay, who's gonna control after Johnny Boney puts the tape in there, takes it out for tonight? Where does that tape go? Who has control of that tape?
The requirement under the ordinance is that they store,
Who is
tapes
they?
the owners
Okay, okay.
store
They
tapes
store, they have control of.
for 90 days.
Okay, I understand.
With
I
access
missed
by
that.
your
I
department.
missed that.
In other words, this is not a criminal activity,
Okay, yeah.
surveillance, it's a health and safety surveillance. Now, it can cross over in the sense that obviously if something occurred on the premises that you're concerned with is criminal activity, that's illegal under the ordinance. And by getting licensed, they've consented to that sort of surveillance, you know.
How about a sign as they come in, videos being taken?
Well, you know, you and I have talked about that.
Yeah.
I don't have any problem with that. I haven't seen that in cases,
Okay,
but what I would say is, if some judge said, you know, you can have their surveillance, but we don't want a sign, well, that's fine, you know.
forewarned.
Yeah,
People wa-
exactly. I don't know, you know, that's an interesting issue. I don't know how a owner of that kind of establishment would feel about that.
What about a patron?
That's right.
Well, I'm sure the patron would probably appreciate knowing that he's under surveillance.
The patron.
You would appreciate it?
I would think. I
Yeah,
think if you're
a lot of
going, you'd like to know
Like
that,
to know,
I mean, if,
yeah. Yeah, that's what I'm saying,
Yeah.
if you had a sign.
right,
Yes.
so
don't
I
think he- I don't think.
I assume they'd like to know that, you know, they're under
Exactly.
surveillance. I'm not sure they'd appreciate being under surveillance, but they'd appreciate knowing.
I
about it.
think there has to be some sort of sign that would indicate that, so that they're aware.
Well, wouldn't that fall in the business? Not, it's the business.
Well, it's
that-
different than a government entity doing it, you know, obviously, you know, no matter where you go, Walmart.
Right. I mean,
A
in
gas
this,
station,
in
you're
this day and
getting-
age,
you're
I
getting
mean,
recorded.
you don't realize, and as the
Well,
chief
some
could
people
probably
don't
speak.
mind, the way I've seen them going to Walmart's, but they may not appreciate the fact that. this guy
Virtually
go
all
out
of
here-
Walmart stores, inside and outside, have surveillance. Now, they don't tell you that, but that's just a fact. And obviously, in many cities now, businesses have, you know, I mean, there's surveillance all over, inside, outside. But again, you know, should we put that as a requirement? I mean, we certainly could. I just don't know the outcome of that. It's not being done for any other reason but as a courtesy to someone going in saying, hey, you know, you're under surveillance.
I can see the owner wouldn't want it because that might scare some people away.
Yeah, I mean, that's something we can look at.
You
Again,
can always
it's,
toss it out.
right, but,
They won one, so.
you know, the idea we would say to the court is, we wanted anyone going into this establishment to know. The argument against it is, as you both said, is there's surveillance all over the place,
Right.
Walmart, gas stations, banks. You know, nobody says you're under surveillance, you know. Why should we have to be burdened with a sign that may discourage people from something that's, you know, a common activity? An interesting